Ng Yu Zhi walked into every meeting the same way. Calm, credentialed, carrying the quiet authority of a former auditor. He had trained inside the machinery of institutional trust. He knew exactly how it worked. And in Singapore, a city-state whose entire financial identity is built on the word rigor, that credential was not just a resume line. In April 2026, the Singapore High Court reaches the climax of a trial that prosecutors describe as the largest Ponzi scheme in the country's history. 1.5 billion Singapore dollars raised from 947 investors, built on a foundation that was never there. The money moved fast, and it moved quietly. According to records cited by CNA in November 2024, Ng siphoned $201.2 million directly into his personal bank accounts, not through a complex web of shell structures, not buried in offshore layers, but straight in, under his own name, as if the transaction were routine. That figure is not the total raised. That is what he kept for himself. The rest was used to pay earlier investors, sustaining the illusion of a nickel trading empire that generated returns no legitimate commodity trade could produce. The machine ran because the man at the center of it looked exactly like the kind of person who would never run a machine like that. He bought a Pagani Huayra supercar for 7.3 million Singapore dollars. The license plate alone, S11T, cost 1 million. Gone. Spent. These were not assets hidden in a trust or parked offshore under a nominee name. They were physical objects, registered, visible, driven. The Pagani is one of fewer than 100 ever built. In Singapore's compressed geography, where every car on every road is a declared financial statement, Ng Yu Zhi chose to make his theft visible. Chrome finished, street legal, and priced above the annual salary of every investor who trusted him. The court raised Ng's bail to 6 million Singapore dollars. His 72-year-old father stepped forward to cover part of it. Life savings, transferred to secure the release of a son whose name was already attached to a billion-dollar fraud. That detail does not appear in the financial filings. It appears in the court record, a single human fact sitting beneath the institutional arithmetic. The investors who wired their money into Ng's funds were not reckless speculators. Many were professionals, retirees, individuals who had done what every financial advisor tells you to do. They checked the credentials of the man they were trusting. The credentials were real. The nickel was not. As of April 2026, Justice Mohamed Faizal of the Singapore High Court is presiding over a trial that has already stretched across years of pre-trial litigation, with 947 investors still waiting to understand where their money went. Some of it bought a car. Some of it is offshore. The full accounting is not yet closed. The scheme described earlier needed a product. Ng Yu Zhi told his investors he was trading nickel, physical nickel, warehoused and shipped, the kind of commodity that leaves a paper trail across 3 continents. He told them he had supply agreements with real mining companies, real counterparties, real contracts. Poseidon Nickel Limited, one of the named suppliers, testified in court that no such agreement had ever existed between them and Ng's companies. Not a draft, not a letter of intent, not a single signed page. No nickel existed. The entire commodity layer of the operation was a surface, a set of documents describing a trade that was never placed, in a warehouse that has never been located. The documents themselves came from a specific place. According to Singapore High Court judgment SGHC 143, handed down in July 2025, an employee named Justin Chong forged bank statements from BNP Paribas and fabricated contracts with the Russian metals trading firm Raffemet. These were not amateur productions, crude photocopies, or obvious alterations. They were documents designed to pass through the compliance departments of institutions that process billions of dollars in due diligence every quarter. BNP Paribas is one of the largest banks on Earth. Raffemet is a real company with a real trading history. The forgeries borrowed the credibility of both, attaching real institutional names to transactions that never happened. The weapon was not a secret. It was a simulation. The forgery didn't just imitate a bank statement. It anticipated the checklist of an investigator. He understood, from the inside, exactly which documents triggered compliance review, which signatures carried institutional weight, and which letterheads closed the conversation before it began. The credential was not incidental. It was the mechanism. The credential worked. When a man who once audited books for a living presents you with a BNP Paribas statement confirming a nickel position, the question most compliance officers do not ask is whether the statement itself is real. In April 2026, the Singapore High Court continues proceedings that prosecutors have structured around 58 witnesses across more than 50 scheduled trial days. That number is not a measure of complexity for its own sake. It is the forensic footprint of a fraud that was built in layers, each layer requiring its own set of witnesses to dismantle, each forged document requiring an institutional representative to testify that their organization never produced it. 50 days in a courtroom is what it costs to reconstruct, line by line, a transaction history that was invented. The machine ran for years. Taking it apart takes longer. Justice Mohamed Faizal of the Singapore High Court is the presiding judge. The case before him is not a dispute about a failed investment. It is a criminal reconstruction. The court working backward through a manufactured paper trail to establish, document by document, what was real and what was forged. The forgeries are now exhibits. The forger is a named party in a high court judgment. The commodity never moved. The fraud described earlier needed more than one person to function. Lee Si was a director of the envy companies, not a passive name on a filing, but an active participant whose role the Singapore High Court examined in detail in judgment SGHC 143, handed down in July 2025. The court found her personally liable, not the company, not a fund, her, as an individual, her name attached to a judgment that would follow her out of every boardroom, every bank, every professional relationship she had spent her career constructing. The credential that opened doors had a co-signatory, and the court named her. The personal liability figure attached to Lee Si in SGHC 143 is $842 million. That is not a fine. It is not a regulatory penalty with a payment schedule and a compliance officer. It is a civil judgment, a number that sits against a human being's name in a public court record. The full weight of the law's arithmetic applied to one person's balance sheet. On September 18, 2025, Lee Si was declared bankrupt. She was bankrupt. The executive, who had been a director of a company managing hundreds of millions of dollars in investor funds, could no longer legally manage her own financial affairs. The system that had made her powerful enough to be named in a billion-dollar fraud made her, in the end, nothing. The investors who lost money in this scheme were not abstractions. They were 947 individuals who had done what the financial system tells you to do. They verified credentials. They reviewed documents. They trusted the institutional names on the letterheads. Some of them recovered. Some of them are still waiting, their claims filed, their futures suspended in the machinery of a trial that is not yet concluded. Witness testimony confirmed in November 2024 that at least 2 of them did not survive the pressure of the case. 2 did not. There is no financial figure for that. No judgment covers it. No exhibit in the court record carries their names. As of April 2026, the trial continues. The forgeries described in SGHC 143 are exhibits. The witnesses are being called. But there is a number that the court has not yet fully accounted for. Hundreds of millions traced to unrecovered offshore accounts. The warehouse coordinates that would confirm the physical existence of the nickel, the commodity at the center of every forged document, every fabricated supply agreement, every investor pitch, have never been produced. The warehouse may not exist. The money in those offshore accounts has not moved in a way that makes it findable. The trial is reconstructing the fraud. The fraud is not yet fully reconstructed.